He's not able to.
I don't know that answers my question.
Could you repeat the question, please?
Why didn't he turn himself in on time?
He had childcare issues.
For 12 to 13 hours? Court calls the case, People versus Matthew Bailey.
Been done with Assistant Public Defender on behalf of Mr. Bailey, who is joining me at the podium.
Your name, sir? Matthew Bailey. All right, what are we doing?
Your Honor, Mr. Bailey would like to demand his exam.
Is all discovery complete?
I believe so, Your Honor.
People have their witnesses available on the 9th. I do believe. Preliminary examination in this matter in person will be set July 9th, 2024, 9 a.m. That is before me. Bond will continue.
Your Honor, may I address bond?
Briefly.
Your Honor, Mr. Bailey was ordered to turn himself into the Washington County Jail. He did so, I believe, approximately 12 to 13 hours later than he was ordered by Magistrate Fink. At this time, we would ask Your Honor to reconsider. I think a GPS tether would provide a guarantee of safety to the community, especially with the
Why didn't he turn himself in on time?
Well, Your Honor, I think he has ties to the community. The tether would keep everyone safe, and he's not able to.
I don't know that answers my question.
Could you repeat the question, please?
Why didn't he turn himself in on time?
He had childcare issues.
For 12 to 13 hours?
That's what he told me, Your Honor. I mean, he needs to find alternate childcare. It's not just.
Go ahead. Anything else?
No, Your Honor.
I don't need a response from the people. Motion for bond reduction is denied. Bond will continue as it is. Thank you. Court calls the case, People versus Amory Thrower. Oh, finally, she's going to get up and she gets to play today. No, really. Thank you, Ms. Rosa. Because all day she's been sitting back there. The only reason Bellinger's even still afloat is because she's been helping behind the scenes. And now, oh, well. Okay, maybe that was a bit harsh, but.
Good afternoon, Your Honor. Maisie Berger requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Attorney Jay Bellinger, representing Amory Thrower.
Are you reading that?
I almost have it memorized.
Hold it. Man, this has nothing to do with you. I got to deal with it. Why don't you have that memorized?
I'm not good with numbers.
You're what?
Not good with numbers. The 8.120, I get it messed up every time.
Oh, okay. But the rest of it you got.
Yes.
So you just had to have the 8.120.
Absolutely.
Okay, you got to just sort of lock that in.
Okay.
Before that happens.
8.120.
There you go. So the reason I think you had to read that is because Bellinger doesn't let you do enough case. He gets up there and shows them himself. If he lets you do like, how many do you have today? You have like 8, 9, 10.
She's just throwing her the bus all the time, though.
What? No, well, you don't send her up there on the ones that are kind of messed up.
I tried.
I know.
I just want you to have a good impression of me, not the cases that are hard.
What?
I want you to have a good impression of me.
I have a good impression of
Oh,
you.
good. Oh,
It's
good.
him. No. No. Okay. That was my second cheap shot. I'm sorry.
I'm a punching bag.
Oh, now everybody feels bad.
Thank you, Jay. Oh.
Seriously? That's the only person who's ever said that.
You're correct.
Well, I know. That's why everybody in the room was shocked. Permission to practice is granted.
Thank you, Your Honor.
Ma'am, this has nothing to do with you. You're good, okay?
We would like to set for exams today, pending a tentative resolution.
I don't know what that meant. You want to set it for exam?
Yes, we would like to set for exam today.
Oh, okay. Is discovery complete?
Yes, Your Honor.
Would the people have their witnesses available on the 9th? Preliminary examination in person will be set July 9th, 2024, 9 a.m. before Judge Burke. Bond will continue. Anyhow, court just called the case. People versus Juan Osorno.
Assistant Public Defender Chelsea Vergils with and on behalf of Juan Osorno. Please state your name.
Juan Osorno.
Oh, all right. What are we doing?
Your Honor, we would ask you for an adjournment on this case to continue plea negotiations. And may I address bond?
Why you want me to lock him up? No, go ahead.
No, thank you, Your Honor. So today, I understand there is a no-go-to order in place in a GPS tether on my client. I'm just asking you to consider removing the GPS tether. There has been no bond violations. The tether is really hurting his ankle. I won't go into the gruesome details, but causing him a lot of physical pain. And my client has very little criminal history, so just a misdemeanor. I don't believe anyone was injured in the allegations here. So I understand the no-go-to order is still in place at this time, but we're just asking you to consider removing the tether.
Response from the people.
I'm just concerned that the defense counsel approached me today about changing the bond conditions so that he could go back to that area because he'd like to rent an apartment there. And said the victim had moved out, that they were no longer at the apartment, and I don't have any knowledge of that. So not knowing where the victim is and trying to change where, you know, the tether taking up, I'm concerned about that without talking to the victim, to be honest. This is a case where there's 2 counts of felonious assault. We had requested a $10,000 bond. They were given it to me to get a $10,000 bond. Obviously posted it, but I'm concerned as to the victim's whereabouts, that they obviously know that she's not in the area anymore, and if he needs to remove the tether, we don't have a good address for her right now.
May I have a brief rebuttal?
Yes.
Thank you, Your Honor. I don't think that there's been any allegations of my client trying to contact any complaining witnesses in this case. And again, I do understand, and he understands there would still be a no-go-to order in this case, which I think he can continue peacefully abiding by. It's just regarding the tether, Your Honor.
Well, I guess if so, what you want is just a tether removed.
Yes, and we have no objection to a go-to order or a no-go-to order for wherever the complaining witnesses are residing at this time. In the future, we may ask to change the order, but not today.
Well, I'm not going to change that until they have an opportunity to have the alleged victim at least voice what concerns they may have regarding the removal of the tether. So I'm going to deny your motion for a change in bond condition. I'll set the probable cause for July 18th. Will that be enough time for you, counsel? 2024 at 9. So his bond will continue. If you're having problems with the tether, GPS tether, go over to community corrections if there's some problem with the fitting or whatever on it, okay? Yes, sir.
So when I first got it on, the tech said I had a weird shaped leg and she kept it super loose because she couldn't make it any tighter. The tech who installed it said I had a weird shaped leg. And so it's just banging around. I'm like, bloody.
So
it's
like, okay, go over there and have them take a look at that. And if there's an issue, they will contact the court if there's a significant issue. All right.
Thank you, Your Honor.
Did you want to say something else? Or?
The first magistrate I spoke to, Fink, she said it wasn't on her. She told me I didn't need to have it, but somehow I had to have it to leave jail. Originally, when I spoke to her via the Zoom conference, said I didn't. There's no reason why we can't believe you can't abide by court orders. Those are her direct verbatim words.
She's the one that signed the tether order.
But she told me over the Zoom that I didn't need it.
I wasn't there. All right.
Thank you, Your Honor.
Thank you. Court calls case People versus Jillian Carey.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender appearing on behalf of Ms. Carey. Ms. Carey, please state your name for the record.
Jillian Carey.
Thank you. I have spoken to the people and to Ms. Carey, and to who will be her attorney, Mr. Belota, Michael Belota. He is apparently going to be coming in on this file.
Making stuff.
I got the email, Judge.
First of all, I've got a social worker leaving. Then gives us the name of an attorney. I ain't know her.
I don't know this guy.
And I pretty much know everybody.
Well, somebody saying they're an attorney emailed me and said that he is in federal court today and couldn't be here, but asked me to adjourn it. He said 4 weeks is ideal. But if not, 2 weeks, he'll make it work.
I don't know you like that.
So I am requesting on his behalf and my client's behalf.
Ma'am, you've hired an attorney. Is that
Yes.
okay? He hasn't sent a substitution in though.
No, Judge.
What, just sent you an email
Yes,
saying
Judge.
I'm stepping in?
Yes, Judge.
Stop showing your phone.
It's the truth.
He's telling the truth.
Okay, I believe her.
Okay, thank you. Last time I did me, I'm like, I got the proof this time.
July 25th, 2024, 9 a.m. She hadn't vouched for you. Fine, continue. Thank you.
Thank you, Judge.
He was on our docket yesterday. He's a Colorado VOC. They did not sign in.
Oh,
I have the date. You want to put that on?
oh, that's right. Okay, that one. Okay. Because they can't do Thursday. Court calls the case of the people of the state of Michigan versus Elijah Kyler.
Assistant prosecuting attorney Morgan LaRosa on behalf of the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Elijah Kyler. Sorry.
Okay, on this one,
I informed him.
you did about yesterday and that they can't hear these cases on Thursdays. So we have to set it for Wednesday. And so I will set this, I'll adjourn this probable cause out to August 7th, 2024 at 9 a.m.
And I believe it's a competency.
Is it?
Yes.
That was my understanding as well.
But the issue is that there was a
That's right.
appointment back in 2022.
Mm.
So I know that he's in custody in Colorado. I don't know if the CFP can do evaluation remotely, but I think we would probably need a new order.
Okay, I will sign a new order. I
can.
don't have a problem doing that.
My understanding is that they are capable of doing that. I have experience with that with them. So I will drop another order and submit that to the court this afternoon.
All right.
Thank you.
Thank you. That's- Yeah.
Sure.
Did you get a chance to talk to your client yet? Oh. No. It's like baking bread. It's not quite done. So we'll call it up. We'll call it up in the next one. What? Do I want to stand in recess? What? It's like baking bread. Well, oh, I'm sorry. My bad. Court is standing in recess.
All rise.
Court calls the case, People versus Eldon Scomp.
Ready, Judge. Portia Feaster, Assistant Public Defender, on behalf of Mr. Scomp. Mr. Scomp, please state your name for the record. I'll say it a little loud so I can hear you.
Oh, sorry. Eldon Scott Scomp.
Okay.
Thank you, Judge. This is our second PCC. We've spoken to Mr. Scomp. I believe he's requesting this matter be set for preliminary examination, please.
Discovery is complete.
That's my understanding, Judge, yes.
People have their witnesses available on the 9th. Preliminary examination in person, July 9th, 2024, 9 a.m. before Judge Burke.
Judge, I believe Mr. Scott wants me to renew the bond motion I made at his last hearing.
Pardon?
I believe Mr. Scott would like to renew the bond request I made at his last hearing.
Yeah.
If you don't mind. I made a motion at his last hearing for a bond. He indicated that he has a manager, someone who supervises his business, who you work for, right? His boss, who has a farm with multiple acres that he can go live on. He is requesting Your Honor consider allowing him to go do that. You previously declined to do that, but he wanted me to bring that back up to you. He also noted that he wants to get back to working because he's in fear of losing his actual home. And so he wants to make sure it doesn't go into foreclosure. And so he wanted me to renew my request for a bond, Judge.
I don't need a response to people. I recall the people's response the last time motion for bond reduction denied bond was defeated. Thank you.
Thank you.
Court does call the case of the People versus LB Jackson.
Andrew Childers appearing on behalf of the people.
And may it please this honorable court, good afternoon. Byron Pitts, read on behalf of Mr. Jackson, who is appearing by Zoom and consents to having this hearing by Zoom.
Mr. Jackson, can you state your name, please, sir? You need to unmute. Okay, you're talking to me, but yeah.
Let me, Judge, let me call him, if I may.
Okay, yes, go ahead, cuz.
Okay, give me one
Just
second.
needs to hit the microphone button. Now,
Yeah.
oh, there
we go. There we go.
We got it. State your name, sir.
LB Jackson.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating while impaired or operating while intoxicated, second offense, the 1-year offense. Upon his successful plea, that's an added count 5. Upon his successful plea, counts 1, 2, 3, and 4 would be dismissed. That's the court's full understanding of the agreement.
And may it please this honorable court, that is our understanding as well, Your Honor.
That's correct, Judge. Thank you.
All right, very good. Mr. Jackson, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
State your name for the record, please.
LB Jackson Jr.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor, punishable by up to 1 year incarceration, a $200 to $1,000 fine plus court cost, 5 days to 1 year in jail. Court could order community service and any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, sir.
All right. I also have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Burke in the 15th District Court. You understand that, sir?
Yes, sir.
Understanding all of that, you still wish to plead guilty?
Yes, sir.
All right. And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, that you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form previously, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
You have it there. I need you to look at or remember paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
March 2nd, 2024, at the location of Eisenhower Boulevard near State Street, City of Ann Arbor, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
Do you recall what you had and how much?
No, sir.
All right. Were you stopped by the police?
Yes,
or was
sir.
there an accident?
I was stopped by the police.
Why did they stop you?
They said I made a just turn. I guess I made a sharp turn, an illegal turn.
Okay. You're not disputing the right of the police to stop you in this case, are you?
No, sir.
All right. Were you ultimately arrested?
Yes, sir.
And were you taken to the police station or were you taken to the hospital?
I was taken to the hospital.
And there was a blood draw?
Yes, sir.
And what were the results of that blood draw?
I was over the alcohol limit.
We have the...
It was a 0.218 was the blood toxicology.
Okay. If I told you it was a 0.218, do you have any reason to dispute that, sir?
No, sir.
And counsel, you would stipulate to those blood test results?
With Your Honor, yes.
All right, thank you. Sir, had you previously been convicted of operating with a high BAC on or about January 23rd, 2013 in the 1482 District Court, and or operating while intoxicated on or about March 31st, 2016 in the 14B District Court?
Yes, sir.
Was that a yes?
Yes.
Okay, thank you. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied, sir.
Defense is satisfied as well, Your Honor.
Court will accept the defendant's plea to count 5. Counts 1, 2, 3, and 4 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report and screening and assessment is ordered. Sentencing in this case will be July 12th, 2024, 9 a.m. before Judge Burke in the 15th District Court. Bond with its conditions will continue.
Your Honor, where is defendant to go? Who is he to contact as it relates to getting the pre-sentence report?
Contacting 15th District Court probation.
Okay. Got it.
You got it? Okay.
That's okay. Look, 15th District Court probation. I'll take care of it.
Okay. Thank you, sir. All righty. Thank you.
Your Honor, take care. Good seeing everyone. Thank you.
Mr. Ganatra, if you could please start us off, sir.
Good morning, Your Honor. Nimish Ganatra, Senior Assistant Prosecuting Attorney on behalf of the people. Your Honor, at this time, the people move to waive any conflict between this honorable court and the Office of the Public Defender. Prosecutor's Office does not have a conflict, but if there's one present, we waive that for all the cases. Prosecutor's Office and the Public Defender's Office before this honorable court.
Thank you. Ms. Gaines.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender. Your Honor, we too do not believe that there is a conflict, but if there are any conflicts.
The court, for its part, also does not believe that there are any conflicts either under the Michigan court rules or the cases decided they're under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Ladies and gentlemen, we have a very packed courtroom, and I'm going to make an announcement and give my admonishment to those that are in the courtroom. There are some cases that people certainly are here to see and to witness what happens. However, I want to make it very clear that this court will not tolerate any disruption to these proceedings. If necessary, I will have you removed from the courtroom, and the deputies will escort you out of the courtroom. So I would ask that everybody that is in the courtroom, those that are outside of the courtroom, understand and govern themselves accordingly. Thank you. Court calls case People versus John St. Germain.
With Overwater Assistant Public Defender on behalf of Mr. St.
Your name, sir?
John St. Germain.
Thank you. What are we doing?
Your Honor, I'm be asking to adjourn the probable cause conference. I still need video on the new case, and I would ask to address the issue of bond.
July 11th, 2024, 9 a.m. The probable cause conference as to bound.
Your Honor, a warrant issued for my client when he failed to appear for court in the last couple of weeks. He was at that time homeless, residing in Hamburg, Michigan. He did not have transportation to get down here. That's also why he was not testing at the time. However, he has been able to resolve that issue. If released, he'd be staying at an address in Whitmore Lake with a couple friends of his. My office has spoken with these people. One of the people who resides there is a social worker. She did confirm to our office not only that Mr. St. Germain can stay there, but also that she would be providing support for him for his sobriety. She and her partner would also provide transportation for him so that he can get to testing and get to court. He did try to get down here to turn himself in. He was actually walking to Ann Arbor when he was arrested. He is not a flight risk. He insisted that I inform the court that he meant no disrespect to this court when he failed to appear. He does admit that he has a drug problem, and that is something that he is working on and will be entering into outpatient treatment as soon as he gets out of custody. And again, does have the assistance of a social worker with whom he could reside.
He didn't appear here and he didn't turn himself in. What was he picked up for?
Can I?
Yes, go ahead.
That's the new case that you have today.
Got it.
The officers from Rosefield Township saw him. A call had been made about a suspicious person checking into windows of cars. Somebody saw him doing this, called them up. They looked at him, saw that something didn't seem right. They confirmed he had a warrant. He resisted arrest. When they arrested him, they also found controlled substance in his possession, specifically methamphetamine. He was discharged from MDOC earlier this year, it's my understanding, for a prior home invasion first attempt conviction. The reason for the discharge was probation violation, technical violation. He has 8 misdemeanor convictions in addition to the aforementioned felony conviction. There's also a 7411 that he received for possession of meth, which I believe is 2021, fairly recent. Guidelines are 5 to 23 on the Class D felony.
Got it. Motion for bond reduction denied. Bond will continue both men. Thank you.
What was the date for probable cause?
July 11th.
Thank you.
Court does call the case of the people versus Leo Stringa.
Assistant Public Defender Natalie Pate on behalf of Mr. Stringa, who is approaching. Say your name for the record, sir.
Leo Stringer, Your Honor.
Thank you, Your Honor. As the PCC, we are respectfully requesting a 2-week adjournment, and I would like to briefly address bond when appropriate.
Briefly, go ahead.
Thank you, Your Honor. We just respectfully requesting for on these files for Mr. Stringa be allowed to be released to treatment.
Any objection from the people on that?
Again, Your Honor, the only thing I would ask is that if the treatment center that Mr. Stringer cannot check himself out of.
Defendant, I will set the probable cause conference. You wanted 2 weeks out?
Yes, please, Your Honor.
July 11th, 2024, 9 a.m. for probable cause. Bond will continue. Defendant may be released to inpatient treatment on a PR.
Thank you very much, Your Honor.
Court calls case people versus DeAndre Brandon.
Assistant Public Defender representing Mr. Brandon. I apologize. Please come forward. I apologize to you, Ms. Willingring, as well as my client. Something came up and I was asked to go to the lockup. With that, we have had an opportunity to discuss this matter. There are no offers of, and my client wishes to set for a preliminary exam. Is that correct?
And you have all the discovery.
That is my understanding. I believe we did adjourn it previously.
And would the people have their witnesses available on the 9th? Preliminary examination in person, July 9th, 2024, 9 a.m. before me. Bond will continue. Court calls case people versus Daryl Williams.
Assistant Public Defender Jay Bellinger on behalf of Mr. Williams to approach it.
Your name, sir?
Your Honor, I've been in communication with Ms. Willenbring. I do need to get discovery on this matter yet. I would just be asking for a 1-week adjournment to collect that and review it.
That's the only thing holding it.
That's correct, Your Honor. That's correct. I'm sorry.
That's not.
I was just
Okay.
I was just trying to correct that myself. So my apologies. That is not correct information. He's not being only held on this.
Probable cause conference will be adjourned July 11th, 2024, 9 a.m.
Thank you.
Thank you.
All right, I'll continue. Court calls the case people versus Thelonious Williams.
Your Honor, David I. Goldstein appearing on behalf of the defendant. Your Honor, if it's okay with the court, I'm not going to turn my video on. The audio is very, very dim. And if I turn the video on, you're going to be looking at my ear, and I don't think the court wants to do that.
Right, very good. That's fine. Your name, sir?
Thelonious Williams.
All right, what are we doing on this?
Your Honor, I believe I have all the discovery. I have the written discovery. I didn't see any notes in there about any video, so we're asking the matter to be set for an exam.
People have their witnesses available on the 9th?
There are 2 media notices in the file. One was already turned over to the defense, and the other one is a new media notice. So defense counsel still needs these videos.
Oh, Mr. Goldstein?
I don't have any videos, and I didn't see any note in the file about any videos, Ms. Hughes.
106 videos went to the public defender's office on June 7th, and then on June 24th, we received additional videos.
Okay, so that's why I don't have them. Okay.
Okay, you want me to put this out to what date were you here? Also, Mr. Goldstein, was it the 11th?
The 11th, Your Honor, yes.
All right. I'll adjourn probable cause to July 11th, 2024, 9 a.m. that you get the discovery.
Okay, I'll be in touch with Susan. Thank you.
Thank you. Calls the case of people versus Luke Edwards.
Good morning, I'm Rob Jekyll on behalf of Mr. Edwards. Luke, would you state your name for the record? Luke? Can you hear me? Would you state your name for the record?
Jumba. Jumba.
Judge, just so I met with him yesterday for a significant amount of time. I finally got the competency report from the Public Defender's Office, which also included a letter from the Forensic Center dated May 8th, saying that the criminal responsibility had not been done yet, but they anticipate that. I don't believe that interview's been done. I spoke to my client yesterday about that. He was upset that we were going to court today, but I told him when we go to court today, because I don't have the criminal responsibility, I was going to ask for probably a 30-day adjournment in this matter. You understand that, Mr. Edwards? I'll explain to you once we go back there, okay? We're just. Okay?
You told me that yesterday, right?
Yes.
July 25th, 2024, 9 a.m. Bond will continue as denied.
Thank you, Your Honor.
All right. The individuals who were in the courtroom for this particular proceeding, you will leave the court as instructed by the officers. Those that are on the alleged victim's side will remain in the courtroom until such time as you are instructed you may leave. Let's call the case People versus Abdul Sumana.
Good morning, Your Honor. We have Ms. Messina here to interpret.
French interpreter, may I have the French interpreter sworn?
Raise your right hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment to translate from English into French and from French into English in the matter now before the court, so help you God?
I do.
State your name.
Joanne Messina.
Very good.
Good morning, Your Honor.
Bonjour, juge.
Uwe Daus on behalf of Abdul Sumana, standing to my right.
Sumana ici sur ma
Abdul, state your name for the judge.
Abdul, pardon, pour le juge.
Abdul Majid Sumana.
Abdul Majid Sumana.
Thank you.
Merci.
We request an adjournment to July 11.
Pour le 11 juillet.
This is to continue discussion with the prosecutor and with immigration.
Avec le procureur et l'immigration.
Probable cause conference will be adjourned July 11th, 2024, 9 a.m. or as your invite indicates. Bond will continue. Court does call the case People versus Wardell Smith.
Full use on behalf of the people.
Good morning, Robert J. Coe on behalf of Wardell Smith. Wardell, Judge, just a little bit of a background. When we were here on June 6th, Mr. Smith informed the court he was going to hire a private attorney.
Yes, I recall. How'd that go?
Well, I was told today that didn't happen. He was also offered several one-year misdemeanors, a misdemeanor use and a misdemeanor attempted possession of a firearm in a vehicle. I believe that offer would be extended today. The problem Mr. Smith has with that is if there's probation, he's rejecting that. Is that true? You won't take those offers if you have to do probation? Yeah. That all being said, Your Honor, he's rejecting those. I've never spoke with him after that day. I'm asking for a brief PCC matter, and then I'm at
July 11th, 2024, 9 a.m. and we should be ready to do something with it. I'll continue. Thank you. Court calls case People versus Daniel Button. Recall.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Button, who's approaching. Button, will you state your name for the record, please?
Daniel Button. Hands out of pocket, I remember.
And we've reached a resolution on this matter by which my client would be pleading guilty to added count 2 of attempt possession of a loaded firearm in a vehicle. Count 1 would be dismissed. There's no further sentencing agreement. I believe the court should have a copy of the plea form.
Slating to the 1 year.
Yes, Your Honor.
A 5-year would be dismissed. There is also an indication of no delayed or deferred. That's the court's full understanding. May I have him sworn?
Right. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Daniel Button.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor, punishable by up to 1 year incarceration, a $1,250 fine plus court costs. Do you understand that?
Do I say that it wasn't in a vehicle? No, yes.
Yes. You understand that? Also, it requires the mandatory forfeiture of the firearm or device. You understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Do you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form today?
Yes.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights and as well as all the rights on that form.
This is the same. Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
because you believe that you're guilty of this offense?
Yes, sir.
November 12th, 2023, at the location of 160 South Zeb Road in Scioto Township, Washtenaw County, State of Michigan. Were you in a motor vehicle?
He was not, Your Honor. May I have a word here?
I was not.
You know, at that time, at that date and time, did you have a firearm on your person?
Yes.
And that was a pistol?
Yes.
And did you have that concealed on your person?
Yes.
And you did not at that time have a valid CPL?
No, sir.
Judge, I'd ask the court to find a factual basis based on a factual basis being laid out for the more serious offense.
Based upon that, have I otherwise complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 would be dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing will be
August 20th at 1 p.m. for Judge Freshour.
August 20th, 2024, 1 p.m.
Yeah.
1 p.m. before Judge Freshour.
Thank you, Your Honor.
Thank you, sir.
Thank you. Continue. Court calls the case People versus Justin Kinshoven.
Amber Childers appearing on behalf of the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Justin.
Justin Kinshoven.
Your Honor, we would be asking for an adjournment in this case to continue plea negotiations. I'll let Mr. Childers decide how long he thinks we need on this.
I don't decide that. The court decides that.
So how much time did you guys need? I'll tell you how much, 18th or 25th, either one. Probable cause conference, July 18, 2024, 9 a.m. All right, bond
Thank you, Your
continued. Thank you. Court calls the case People versus Jessica Komanek.
Assistant Public Defender, Bedouin for Ms. Komenek, who is not present.
Komanek's not here. Defendant failed to appear. We'll leave out the community corrections bench warrant, which I issued, which is a bench warrant with no bond for her violations. We'd be done, but now I gotta go back. Court calls the case People versus Jennifer Hiller.
Assistant Public Defender Jay Bellinger on behalf of Ms. Hiller, who now appears on Zoom, my understanding. Ms. Hiller, will you please state your name for the record?
Jennifer Hiller.
Thank you. Your Honor, I have spoken with Mr. Ganatra with regard to the potential for additional discovery on this matter, so I'd be asking for 3 weeks so that I can see about getting that.
Probable cause conference will be adjourned July 18, 2024, 9 a.m. Or as your invite indicates, bond continues.
Thank you, Your Honor.
Court calls the case, recalls the case, People versus Jeremiah Fashion.
And good afternoon, Judge. Sydney Rushing appearing on behalf of Mr. Foss. Mr. Foss, can you please state your name for the record?
Jeremiah Faison.
Faison.
All right, what are we doing?
Your Honor, I was just recently appointed on this, so I need to get the discovery and go over it with my client. So at this time, we're requesting an adjourned PCC date.
Conference July 18, 2024, 9 a.m. Bond continued.
Thank you so much, Your Honor. Have a great day.
You too.
Judge, you're not being very smiley today.
What?
I said you're not being very smiley today. There we go. There we go. Much better. I'd love to see it, Judge. Have a great day.
Yeah, I smile like that. That's scary. All right. Court calls the case, People versus Jason Thomas.
Assistant Prosecuting Attorney.
You again, Your Honor, Assistant Public Defender Constable Basin on behalf of Thomas, who's present to my right. Mr. Thomas, can you go ahead and state your full name for the record?
Alan Thomas Jr.
Yes, Your Honor, today is the date and time set for a PCC. At this time, my client is wanting to waive his right to a preliminary exam and seek an offer it.
Has he signed the waiver?
Yes. Mr. Allen. May I approach?
Yes, that's how you do that when there's no bailiff. Yes. Sir, is that correct? You're going to waive your right to a preliminary examination?
Yes, sir.
All right, you understand that that's a proceeding where people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right, people also waive their right.
Yes, Your Honor.
Your Honor, we would just ask for a date about 3 to 4 weeks out because I'm going to be sending him to our wonderful AIM division to get some mitigating information.
Why did he start talking? You know, everybody else who came up here, nobody did that. I'll go back over here now and let's see if we can get this started. Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Belvisi, as to the arraignment.
We would waive any formal readings and stand mute to the charges at this.
Defendant having waived formal readings, standing mute, court will enter a not guilty plea. Pre-trial will be set for August 1st, 2024, 1:30. That's Judge Slay Thursday.
Thank you, Your Honor.
Is that far enough out?
That is wonderful.
Is it?
I appreciate
Great,
it.
because I only have one date. And if you needed a new date, you were gonna have to go down there and get another one. But I think you know that, but you just were trying my patience. Bond continues.
Thank you, Your Honor.
You're welcome.